only do you need the specific jury instructions for, each charge, the second-degree murder, the manslaughter while either leaving the scene, but you need the reasonable doubt, what is evidence, defendant not testifying. So it's volume, there's a lot of it. It takes a couple of hours, and then, they'll start deliberating by, probably late morning or tomorrow afternoon.
Do you think, or Friday afternoon?
Friday afternoon.
Yeah, Friday afternoon. No, it's fine.
Yep.
I just want to make sure we're right. Do you think that this charge conference, while it's usually kind of a boring legal thing, is going to carry more weight this time because of the mistrial?
I think that it's really interesting because there was so much focus on what happened. It actually was mostly after, the jury came back and was there confusion. There are standard jury instructions that go to the jury across the board. So the, judges and lawyers get together and basically, talk about what the law should be and what's the most easy, manageable way to, advise juries who are really lay people of, how to interpret these charges. But because of last year's confusion about how it was going to go to the jury, what the boxes, whether there was going to be a box checked or not. I expect that, especially with Attorney Alessi here, who really has his eye on, all of these appellate issues, that we might have some more really focus on what actually goes to the jury.
Okay, so for the rest of this segment, I want to focus on two witnesses who work for the same company, who I think the defense probably thinks of as their heaviest hitters, some of their best witnesses, and that's ARCA, Dr. Daniel Wolf and Dr. Andrew Rentschler. Let's start with Dr. Rentschler because he was the last witness who took the stand. So he was on for 2 days-ish, over the course of 2 days. And more or less, his job is to investigate whether injuries match a car crash.
That's right.
And he testified that in his opinion, basically unequivocally, there was no crash here.
That's right.
Why do you think the defense closed with him, and what do you think is the overall takeaway?
Well, I think the defense was really smart to close with Dr. Rentschler because it sort of wraps up. You think about when you're presenting a case to a jury, what do you tell them at the very beginning? And what did Alan Jackson tell the jury? There was no collision, right? And so what's the very last thing?
That was his first line, right?
I think so. And so what's the last thing they really heard from, the defense expert, Dr. Rentschler, that based on his interpretation of the data, of Dr. Welch's report, that the way that the Commonwealth theorizes this happened absolutely could not have happened. And that's what ultimately the defense wants to be able to argue to the jury, that, the Commonwealth, try as they might, has not presented enough evidence. And on top of that, you have ARCA, Dr. Wolf, Dr. Rentschler, who say it doesn't make sense.
So I was thinking about this when I was kind of summarizing his testimony in my head. Do you think that the question the jury's really facing as they go into deliberations for this trial is whether or not there was a collision?
I think so. I mean, it's difficult. There's so many things that have gone on, in trial number 1 and then trial number 2. This time it's a little bit more pared down.
Yeah.
And so it's not so much as, are all these other possibilities happening. It's really that even though, yes, you have the evidence at the scene, does it line up with, whether she actually hit him, whether he was hit at all? Do the injuries, you had Dr. LaPosada, you had Dr. Russell testifying that based on, their evaluation of his wounds, the way his body was, in the autopsies, that it just does not line up with a collision. So I think ultimately that's what, in the first trial, the jury really focused on the evidence at the scene. They came back with one question. It was about the search team report. And I think that's probably what they're going to be doing. They're going to be looking at, the different sets of expert opinions, deciding, do they weigh them the same? Does that cancel them out? Do they weigh one more or the other? And then ultimately going back to 34 Fairview and looking at the evidence and saying, does this support a collision or not?
Right. So let's also talk about ARCA's other expert, Dr. Daniel Wolf. We talked about him a little bit back when he was testifying. He did the actual crash reconstruction, the recreation, which included a dummy arm and then also a crash dummy being hit at various speeds by a car.
That's right.
By actually an exemplar Lexus.
Right.
What was your reaction to that testimony?
My reaction to the testimony when it came in on the end of last week was I was surprised because I think the visual of that even though it was a dummy, Rescue Randy, breaking the taillight was impactful because up until this point, even the Commonwealth's own witness had not been able to show that, okay, you know, they're sort of taking these steps to, this is why we think there's a collision, but is it, you know, one of those things that, is it reasonable that a taillight would smash with an arm? And then we saw all of a sudden on this video that, yes, I guess it is reasonable that a taillight could smash with an arm. So in a way, these videos coming in through the defense was surprising because they seem to support the Commonwealth's case. Now there's, you know, there's sort of like niche, more nuanced questions about what the taillight looked like. Was it exactly the same? Were, you know, both the exterior and the interior smashed? And those are the questions that the defense really wanted the jury to focus on. But I think that, you know, I really think the combination of Dr. Wolf and Dr. Rentschler, I mean, they're two clearly very experienced, you know, knowledgeable, qualified experts. So, you know, they were really good for the defense.
Right. Okay. So, but just to summarize what you're just saying about Dr. Wolf, he was saying we did all this testing which showed us that the crash was inconsistent with the crash that the Commonwealth alleges.
That's right.
But in doing that, repeatedly the jury got to watch videos of a car backing up and the taillight smashing on a dummy's arm.
That's right. And not only that, the sort of pirouette that, you know, Rescue Randy did. And to be fair, Trooper Paul, the first time around, there was, you know, much discussion about sort of this pirouette, this spinning that he talked about.
Yeah.
But that's actually what we saw when the dummy was hit. And then the shoe twisted. So it was interesting that, you know, there was really two separate perspectives looking at it. Like, clearly the defense looked at it one way, and I think the Commonwealth, when they saw those videos, looked at it completely differently, which ultimately goes to show that jurors can look at it differently, right? Because you have everybody online, you have commentators, observers looking at it and saying, well, I saw it this way, and the other side saying, I saw it that way. You know, what's that reflective of?
It's going to be so interesting when that jury gets in that room. The other thing I want to ask you about, just for the rest of this segment, is the mood. I've asked you a lot about this. In the last week or so, it does feel as though the mood in the courtroom has shifted. Outside, it's certainly shifted. There's a lot more Karen Read supporters starting to show up. This happened last year as well.
Sure.
But inside the courtroom, it's shifted. There's been more sidebars. There's been more objections. There's been more passionate or emotional arguments from lawyers, both in front of and outside the presence of the jury. I mean, you heard Alan Jackson twice today ask the judge to admonish Hank Brennan for making commentary. Is that just the natural progression of a case when it's reaching the end, or what is that all about?
Not quite to this level. You know, I think this is a long case, right? Like the Commonwealth presented for quite a bit of time. And the defense really didn't get to present their theory of much of anything through cross-examination like they did the first time. So I think there was less stakes in trial number one on the defense's case because they were able to poke so many holes through cross-examination of the Commonwealth's witnesses. In trial number two, Hank Brennan very strategically limited them from doing that.
Didn't give them that chance.
That's right. And so really, from the defense perspective, a lot more rides on what they actually put into that case. So they're making sure that they can ask every question, that every slide gets in, you know, that they can, you know, want both opine as to dog bites, things like that. They're really going to be pushing as to, you know, each specific issue because this is really where their bread and butter is.
On that note, the defense, it seems as though the last trial, they really pushed the third-party culprit theory, right? That somebody else could have killed John O'Keefe, and they even named the people who they thought did.
That's right.
In this case, they focused on alleged dog bites on the arm and also a little bit on Brian Higgins. But otherwise, that has not been the focus of their case. No, it hasn't. And, you know, it's interesting to see sort of where the case has gone throughout, you know, from the beginning. As trials sort of changes, as the witnesses come in. We did see Alan Jackson go pretty aggressively at Jen McCabe. And so you sort of felt like maybe they really were going to the third-party route. Yeah. And then it's shifted at some point, I think, as we saw the witnesses that Attorney Brennan was calling.
filing. And so, then they made the decision to really focus on what we call the Bowden defense in Massachusetts, which is
remind us what that is.
It's essentially, you can put on a case that the police investigation is so substandard, or there's errors or omissions, and then ultimately you get to instruct the jury. You request the judge, what will be happening at the charging conference tomorrow, for what's called a Bowden instruction, that you can draw this inference that, because of the police investigation being so poor, that you don't have to value the evidence in the same way. So, they really, I think that's the straighter path. I've always really thought that was the straighter path to a not guilty, because in trial number one, going full-blown third party really presented only two sort of binary options with the jury, and they went back towards the Commonwealth, it seems. But in this case, remember, we talked about bricks, on the wall. They've been able to poke more holes, I think, this time. So,
all right,
we shall see.
We will be right back with more from Katherine. Thank you for joining us back on this special of the Karen Read trial. The defense rests. We're recapping the defense's case. If you're watching us on YouTube, just remember to like and subscribe. So I'm Kristina Rex. I'm joined here by Katherine Loftus, our legal analyst. Let's get into another witness who I don't know if we expected her to be as controversial as she was, and that's Dr. Elizabeth Lapazada.
Yes.
Former Rhode Island medical examiner, chief medical examiner, who testified that, in her opinion, the injuries to John O'Keefe are not consistent with a car crash, which this is becoming a theme.
That's right.
And also that maybe the arm injuries are from an animal attack.
That's right.
So why was she so controversial?
Well, I think that, one, she was newer coming. We didn't see her during the first trial.
Yeah.
The only medical examiner we saw was Dr. Russell about the dog bites and things like that. And so this was really the first that we heard of her. There was some, question about her credentials, that she had previously been involved in an investigation and subsequently resigned in Rhode Island. But, I think overall she came off as very knowledgeable. I think she appeared self-assured, someone who probably testifies quite a bit. So she was not rattled on cross-examination.
And you talked about how that can make a big difference, the fact that she stayed consistent.
Yes, it can make a huge difference. And particularly some of these experts, they testify for a living. And so part of testifying, just like police officers, is, time and experience on the stand, and you get used to, knowing that the other side is going to be trying to get under your skin, to try to get you to change your mind. And so, I think, she's been a practicing, physician for many years. She teaches at Brown University. So clearly I think she came off as qualified, as likable, and certainly good for the defense. And so that's what the defense is, we see in their cases, really expert heavy. And so we have multiple witnesses now saying this didn't happen, this didn't happen, this didn't happen, from sort of all different specialties.
Right.
And she was sort of another notch and maybe picking off a couple of bricks on that wall.
Yeah, and she is someone, I was wondering if this matters. Like, would the jury consider the fact that she wasn't actually there at the autopsy? Do you think that matters to them?
I think that juries generally seem to give more credit to anybody who's actually involved, only because, it's sort of this common sense analysis, is that if you have firsthand observations and experience, you're really in the position to know best. But that doesn't mean that they diminish the opinions of, a medical examiner who comes in later and, looks at the entire case. But yes, is it most helpful to have Dr. Scotty Bell, who actually saw John O'Keefe's body, who actually examined it? She really is the person who is in the best situation, I think, to opine as to what was happening, at the time. But do I think that they diminish it? No, I think that her opinion, is probably considered to be credible by the jury.
Okay, let's do this one quickly because we've talked about her a lot. Dr. Russell, she testified last trial at multiple voir dires. She believes that the arm injuries are dog bites, and she is an expert in dog bites.
That's right.
Any big impact from her testimony this time around?
Dr. Russell, I think, has become near and dear to all of our hearts. We've seen and from her so much. Voir dires in the first trial, and then testifying, multiple voir dires here, testifying again. I think ultimately she has stayed fairly consistent with what her opinion was the first trial and what she was called for. That, in her experience as a medical examiner as well as a ER physician, that she doesn't think these are consistent with a car accident, and that they're more consistent with dog bites. So, again, I think she checked off the box that the defense needed, because what they're trying to do is, provide, not only say this isn't a collision, but sort of put these little pieces into the jury's mind of all these other possibilities that it could be. And had the police investigated, maybe they could have crossed them off, but they didn't. So,
on that note, has there been enough evidence about if these are dog bites, what the source would be? I feel like we haven't heard the name Chloe.
That's the difficult part. I don't know. I think Jen McCabe was the only one who testified about the dog at all, and I don't think she said the name Chloe. And so, that's always the question, is that the jury sometimes goes back to, okay, if you say there's not a collision, then what happened? And this time around, there is no real inference for the jury. No. In the first trial, it was very clear that there was direct allegations against people in the house.
Yeah.
In this trial, jurors might be thinking, like, what dog? Were they paying attention to the line of questioning about a dog?
Right. Are they thinking it's a wild animal?
That's right. So I think in some ways it can lead to more questions.
Okay, next up, Brian, aka Lucky Loughran, the Plow driver. He testified last trial as well. This trial, he was very adamant about the exact times he plowed that route, that he would have seen a body, that he didn't see a body, and that later in the morning he claims he saw a Ford Edge parked on the the Albert's front lawn. How did he come off?
I think he came off well. He's it's just
A likable guy.
He's a likable guy. He's just a town resident. He works for the DPW. You know, he's just doing his job. Nobody's, especially people who are sort of just thrust into these cases, you know, juries generally look at a little bit more sympathetically. He didn't ask to be involved in this. You know, he's just doing his job in the middle of the night, you know, in a blizzard. And so, but I think his testimony is certainly relevant to the defense. I mean, they're trying to sort of hone in on, you know, nobody saw John, right?
Right.
Jen McCabe didn't see him coming out of the house. Lucky didn't see him. Ryan Nagel, Heather Maxson. And so, and putting this sort of unknown car, the Ford Edge, in front, again, it goes to all these ideas of, you know, could something else have happened? And, you know, maybe we don't even know any more about that, but that's because the police didn't investigate, right? So that's where, you know, it's a little bit of like throwing spaghetti at the wall.
Yeah.
And if enough sticks, then
That feels like what reasonable doubt is, though, right? That's the goal
exactly right.
for the defense.
Right, and so this time around, instead of trying to prove their own case, which is really what they did the first trial, and the jury didn't buy it, you know, I think the more persuasive argument is where they're going, and their witnesses have done a good job to bolster that for them.
Okay, let's talk about a witness who I'm not sure if her substantive testimony meant anything to the case, but Kelly Dever, because just wow was her being on the stand a moment. Current Boston police officer, former Canton police officer, clearly did not want to be there.
That's right.
Was it a risk to call her? Did it pay off? What was that about?
You know, I'm not sure that there was a net benefit for anybody really. She came off as combative right off, you know, as soon as she sat down on the stand, really, with Alan Jackson. She wasn't really that much friendlier to Hank Brennan. And, you know, the goal was to get her, you know, to say what she said to the FBI, you know, 18 months ago, but she has subsequently changed her story. You know, the difficult part of her testimony was because she was really adverse to both sides. We didn't really get what the story was. What is your, she kept saying this sort of false memory, or you wanted me to tell a lie.
Right, she had originally said to the FBI that she saw the Canton police chief and Brian Higgins go in the Sallyport with Karen Reed's car for a wildly long time.
That's right.
But then she recanted.
That's right. And so, but there was no real explanation of the story. Is it, you know, were you confronted with evidence that you weren't actually there?
Right.
And you maybe saw them at a different time, but instead of explaining her change, because listen, sometimes people make mistakes, you know, you have to, you know, it is what it is, you have to explain it, but instead what she did was get up on the stand and basically say, you know, I'm going to be difficult for every single thing you ask me. And I mean, I don't think she benefited the defense, but I don't think she helped the Commonwealth either. I'm not sure that she really served much of a purpose. All
right, let's talk about the witness or lack thereof who has loomed over this trial, and that's former State Trooper Michael Proctor. Now we can say officially he didn't testify for either side.
That's right. That's right.
In fact, the defense wants a missing witness argument, which would mean they could argue that the jury could infer negative things from him not testifying, basically.
That's right. So basically, you know, it's interesting because I think any of us looking at the case a year ago, 6 months ago, would never have imagined that Michael Proctor wouldn't have been called. And it was very tactical on behalf of the Commonwealth. And then in the same way, it was just as strategic from the defense. And so now what the defense wants is to be able to not just point their finger at him in closing, but they also want the jury instructed. It's basically an adverse inference that you can infer because the Commonwealth didn't call their lead investigator, you know, that there would have been something that was favorable to the defense. Now, Hank Brennan's going to be objecting to that. We'll hear that likely tomorrow in the charge conference. There was also a request for a missing instruction on Brian Albert and Brian Higgins, which I think is pretty likely to be denied. But I think there is a fair chance that they get a missing witness instruction on Michael Proctor. I mean, he is the lead investigator. Whether other people can testify to it or not, you know, we had Sergeant Buchanan. They did a lot in tandem. We had other troopers, but
they also called his friend, who ended up reading, or not reading, but confirming the text messages.
That's right. That's right. Yeah, they called, the defense called, you know, and what a tough position to be in as a friend. But, you know, and so think about that. If they can not only say, you know, you had this Proctor who said all these terrible things about our client, the Commonwealth didn't even call him, you know, he had a conflict, all these kinds of things. Yeah, I think it's pretty powerful.
Any guess on how many times if Alan Jackson's doing closings. I actually don't know that if it's Alan Jackson. I'm assuming it is. But how many times will he say the name Michael Proctor in his closing?
Yeah. Well, we want to make sure it's fired former fired,
yes,
fired former.
yes.
Yeah, but hey, you use what you have, right?
Right.
You
Fired
use what you
former
have.
state trooper Michael Proctor.
And the lead, whatever way you want to look at it, the lead investigator in this case was fired essentially as a result of how he treated this defendant. So, you use it over and over.
Especially if they're doing this Bowden defense. I mean, that's what they
right.
have.
That's right.
Right?
That's that's the meat and bones of it. It's really in any case as a defense attorney, it's not something that you get very often, that a police officer is not only problematic in the case, but then you actually have them reprimanded and then fired as a result of their involvement in the case. So
and then you get to retry the case after that happens.
That's right.
Yeah.
So you absolutely use it as much as you can.
Okay, we have just 30 seconds left. I'm going to ask you the question I'm sure you get all the time, and I'm sorry to ask you, but what do you think the outcome is going to be, and how big of a role are closing arguments going to play?
I mean, I think they play a huge role. From, closing arguments are almost the whole thing. I mean, it sounds a little wild to think that you've put all of this evidence in, but, lawyering is about the art of persuasion. And you have two really, really skilled lawyers here in Hank Brennan, and I think you're probably right that Alan Jackson's going to do the closing, and I think both of them are very good at persuading, but in different ways. They're very their styles are different, their tones are different. I think that I still think we'll probably get at this point not guilty on the second degree and the leaving the scene. I think there's a room for a guilty on the manslaughter, but I also think there's a high likelihood of a mistrial. I think that there will be. I think it could be a mistrial again, which I hate to say, but.
But do you just think no matter what, like no 12 people are going to agree?
It's difficult. I think it's difficult because they're both of the cases are the Commonwealth and the defenses are persuasive in different ways, and everybody's looking at it from the outside perspective. People feel so differently that I think
could be
there's a
true
good
in the
chance
jury
of
room
it.
too.
Yeah.
Okay, well, thank you so much, as always.
Thank you.
Thank you all for watching. Remember, you can subscribe to us on YouTube.